This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law's Intellectual Property Review. I'm Josh Block. Can Congress pass a law that takes music that you can hear and play for free, like Prokofiev's Peter and the Wolf, and restore the copyright, allowing a copyright holder to charge for use of the once free music? Coming up, we'll discuss a case that was argued before the Supreme Court last month, Golan v. Holder. The case could alter the rights of millions of works that had been in the public domain, including the movie The Third Man, starring Orson Welles, several works by science fiction author H.G. Wells, and yes, many classical music compositions, including Prokofiev's Peter and the Wolf. But first, a review of recent IP developments reported by Bloomberg News. Lipitor, the world's best-selling drug with $10.7 billion in sales last year, will lose patent protection this month. Pfizer, the drug's maker, will face generic competition for the cholesterol drug and is seeking to secure the market through deals with pharmacy benefits managers. The deals would block patents from receiving the generic version of Lipitor. Medco Health Solutions, the country's third biggest pharmacy benefits manager, has already agreed to block their patients from receiving the generic version of Lipitor until May of 2012. Mark Zuckerberg has until December 1st to respond to a letter from the Congressional Bipartisan Privacy Caucus. The letter, signed by Democrat Ed Markey and Republican Joe Barton, is in response to a recent patent application filed by Facebook. The patent describes a method for tracking Facebook users when they're on other websites. Markey and Barton are asking Zuckerberg to explain why the patent application was filed when the company states that Facebook does not track people across the internet. Louboutin's red-soled shoes have a friend in Tiffany's robin's egg blue box. Christian Louboutin S.A., the French shoe designer, is appealing a district court decision that allows Yves Saint Laurent to continue selling a red-soled shoe, despite Louboutin's trademark. The luxury jewelry company submitted a friend of the court brief on behalf of Louboutin. Tiffany has a registered trademark on the Tiffany blue color and argues that the lower court holding, rejecting a single color for a fashion item, is not supported by trademark law. Last month, the Supreme Court heard oral arguments in the case of Golan v. Holder. At issue is whether or not the court can take a work from the public domain and restore the copyright. I'm joined now by Jessica McKinney, a writer and editor of Bloomberg Law's Intellectual Property Law Report. Jessica, take us back to the beginning of this case. What is Section 514 of the Uruguay Round Agreements Act, and why did Congress pass it?
Congress passed the law to put the U.S. in compliance with the Berne Convention, which is a multilateral international treaty that we signed in 1988. And basically what the law does, it restores the copyrights in millions of foreign works that were previously in the public domain in the United States. The foreign works get automatically restored if certain conditions are met, and the copyright term lasts for the remainder of the term that the works would have received in the U.S. if they had gotten protection at the time they were eligible.
Will you explain what the public domain is? Why do we have it? And what does it mean when a work enters the public domain?
Public domain basically means that there is no copyright on the work. So whatever the work is, it's totally free for the public to use and to copy and to build upon in creating new works. So it's really just a store of knowledge, building blocks of knowledge. Use prior works in the creation of new works without having to worry about copyright infringement or, paying licensing fees to the copyright owners.
I know this seems like a very basic question, but I also know Justice Kennedy focused on this public domain question during oral arguments and what the framers meant in the copyright clause of the Constitution by granting copyright for limited times. And can you give a sense of how that limited times plays with the public domain?
Petitioners in the case, that's one of the key things that they're arguing, that the limited times provision in the copyright clause means that once you set a term, once that term ends and expires, the work goes into the public domain and it's free for the public to use. And in prior cases, it said it's okay for Congress to extend existing copyright terms. But this case presents a different and unique question. This is works that were in the public domain already, and you're putting copyright back on those works.
Tell me about the effect that Congress passing this law had on the works that had been in the public domain and were now, I guess, taken out of it. What happened?
Well, now the copyright owners, they have copyrights in the works, and If you're in the United States and say you're an orchestra conductor, a performer, if it's a movie, you're distributing and selling the movies, you can no longer do that without violating the copyright in the restored work. So, it's a huge issue. For education, like educators use these works, people rely on them for their income and their livelihoods, and they can no longer do what they've been accustomed to doing for the past how many years because of this act.
Are there any specific examples? I had heard one of a high school orchestra that played, some composition that no longer can. Have you heard any other examples?
Just things of that general nature. It's not that they no longer can, it's just that it's no longer
They pay
feasible from a
fees.
cost perspective.
Right.
If they pay thousands of dollars per performance, which is probably what the copyright owner would want, then, as a practical matter, they can't do it if they're, a middle school orchestra, or even a college orchestra. It's just not feasible.
Who are the plaintiffs here? What did they want when they filed this case? And also, the case has been kicked up and down the courts for some time. When was it originally filed?
Well, the case was originally filed way back in 2001. It's been up and down the courts, in the district court twice, the 10th Circuit Court of Appeals twice, and now going up to the Supreme Court. And the plaintiffs are just a variety of people that have used works in the public domain, such as orchestra conductors, educators, performers, film archivists, and motion picture distributors.
Will you explain the specific issue that the Supreme Court is being asked to decide?
Yes, it's actually two discrete questions. The first question is, does the Copyright Clause of the U.S. Constitution prohibit Congress from removing works from the public domain? And that's in Article 1, Section 8, Clause 8. And that states Congress has the power to promote the progress of science and the useful arts by securing for limited time to authors and inventors exclusive rights to their writings and discoveries. So that's the Copyright Clause in the first issue. And the second issue is, does Section 514 of the Uruguay-Brown Agreements Act of 1994 violate the First Amendment?
And explain that First Amendment issue, or it's a freedom of speech issue. How does that work? How were people using these works that now, if they use them, they'll somehow have a limit on their First Amendment right?
The work's in the public domain, then you're free to use it. So, in effect, you're using the speech of others to build your own speech and your own expression. And if you're denied, those building blocks, speech of others that you're accustomed to using, then it impedes progress and knowledge, is what the petitioners are arguing here. So that's the First Amendment issue.
If these works are in the public domain, our copyright laws will be out of sync with many copyright laws in the rest of the world. Why does that matter?
Well, that's what the U.S. is arguing in the case. They're saying, hey, we enacted Section 514 to put the U.S. in compliance with Berne Convention and all of these other countries that are signatories to the Berne Convention. And, they're saying that, to be a member of Berne, Article 18.1 says that you have to grant copyright protection to works that are not yet in the public domains of the country of origin. So for instance, if a work over in Russia is not in the public domain there, we should be granting that work copyright protection in the U.S. And the question is, how to go about doing that constitutionally.
The petitioners here are the parties that would like these works to be back in the public domain. What are the arguments that the petitioners are making?
One main argument is, the parties are really disputing, how to define the public domain. What exactly does that mean is the first issue. The petitioners are saying that, going back to when the first U.S. Copyright Act was enacted back in 1790, they're saying that was the first U.S. Copyright Act, therefore that was when the public domain first came into existence. And also since that time, petitioners argue that, 200 years have gone by and, Congress has left the public domain intact. They might have expanded the scope and the terms of existing copyrights, but they haven't done what they've done here in Section 514. And the government, on the other hand, they're saying that the public domain, came before the first Copyright Act. They're saying before the Copyright Act was enacted, there were all kinds of works that people were free to use, and once you gave copyrights, automatically you couldn't use those works anymore. So they say that the public domain pre-existed the Copyright Act, and therefore you have to look at that when you're considering the history of the Copyright Clause.
Do you have a sense from the questioning by the justices how the oral arguments went?
Somewhat. I mean, it's always hard to tell how any given case is going to go, especially before the Supreme Court. Some things that I noticed some of the justices mentioned, I think Justice Ginsburg was a little more sympathetic to perhaps the government's interest in saying that, why shouldn't we give foreign contemporaries the same protection that American contemporaries get? But on the other hand, Chief Justice Roberts was saying that, there might be First Amendment issues. One day I'm totally free to perform the works of a foreign composer, and then Congress enacts Section 514, and the next day I can't without committing copyright infringement. So maybe that presents a First Amendment problem. Justice Scalia also touched on the fact that, Congress either has powers under the Copyright Clause or it doesn't. It can't just rely on the fact that it signed a treaty to give it powers that it doesn't have under the Constitution.
Do other previous copyright decisions by the Supreme Court give an indication of how the court might come out on this case?
Well, the main copyright case is the Eldred v. Ashcroft case that was decided back in 2003, heavily cited by both parties in their briefs here. And in that case, the issue was Congress extended the terms of existing copyrights, and, the question was that constitutional under the Copyright Clause in the First Amendment. So the same issues here, but a different scenario. In that case, the court said Congress was within its Article I powers with the Copyright Clause. And the other issue, though, that is slightly more interesting is that the court said that to apply heightened scrutiny under the First Amendment depends on whether Congress altered the traditional contours of copyright protection. So that's kind of the key language. In that case, they said Congress didn't alter traditional contours because Congress had always consistently extended the terms of copyrights since the first Copyright Act 200 years ago. In this case, petitioners are saying, well, this case is completely different. 200 years went by, and Congress has amended the Copyright Act 19 times, but it's never really touched the public domain in that time.
That's Jessica McKinney. You can learn more about the topics discussed on today's podcast, including Golan v. Holder, at BloombergLaw.com. You can find new IP podcasts each week at Bloomberg.com/podcasts, at YouTube.com/BloombergLaw, on iTunes, and on the Bloomberg Law website. Thank you for listening.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.